Before we get started here with our panel, I'd like to address something that Anacita talked about, about paying people coming in. Part of the problem is that in order to get paid by the state in some kind of some contract and stuff, you need to waive your tribal sovereignty, and that ain't happening. And so that's the qualification why it doesn't work. And as far as DWR goes, I don't know what they do with tribal people, but they might look to Caltrans because we've had contracts to win them and win to, and we're not federally recognized. We've had contracts with Caltrans for 4 or 5 years for monitoring, for cleanup, for all kinds of things, and it just gets paid out of a fund in a straight bid. So I just thought I'd put that out there.
I really appreciate that suggestion, and definitely we'll look to Caltrans to make sure we can replicate what they're doing. Thank you so much for that. Good morning.
Good morning. My name is Makena Kauhane, and I'm a student attorney with the Stanford Environmental Law Clinic. I'm here on behalf of the Delta Tribal Environmental Coalition, or DTEC. We will comment on issues concerning governance and participation. So next slide, please. First, the voluntary agreements perpetuate an unjust and inequitable water rights regime. As DTEC has extensively documented, discrimination, racism, and dispossession are woven into riparian and prior appropriative rights in California through intentional state action. Tribes are the original stewards of the state's waterways since time immemorial, but the state's first in time, first in right regime has undermined tribes' inherent title. From the mid-1800s, the California state government forcibly removed tribes from their ancestral lands, robbing them of their inherent title to land and the water rights attached to it. The government also worked in tandem using exclusionary policies like redlining to remove people of color from their land, depriving them of the opportunity to have a water right. The 18 treaties negotiated between the federal government and tribes between 1851 and 1852 should have reserved to California tribes trust land and water necessary to fulfill the purpose of the reservation. Instead, the U.S. Senate refused to ratify the treaties and kept them secret for over 50 years. The state has yet to make meaningful amends for its intentional deprivation of tribes superseding federal reserve rights. Appropriative rights holders, many tracing their rights back to the colonial era, still organize how water is governed and used today, particularly in the Bay Delta. For example, several VA parties, including Glen Colusa Irrigation District, trace their water rights back to this era. This history has clear through lines to the present. According to a DWR analysis, 91% of water rights holders are white, as are the majority of people who direct water agencies and agricultural water districts. While the board has acknowledged this unjust foundation in its racial equity report, it continues to stop short of meaningfully repairing this history and actively engaging tribes and other communities of color. The VA process not only reflects this history, but is even worse. It bakes it into water quality standard setting. For example, laws like the Porter-Cologne and Federal Clean Water Act envision the state independently establishing environmental constraints on diversion through water quality parameters necessary to protect beneficial uses and public trust interests in the watersheds. Such parameters include science, public processes, and we believe implementing TEK in partnership with tribes, as well as flows and temperature needs. In lieu of this process, the voluntary agreements allow water rights holders who establish their so-called right through an intentionally violent and discriminatory regime to extend their right into setting constraints on their use. It regulates the state water board from regulator to enforcer of contract. This is not what law or equity envisions, and it trades away the interests of tribes, communities, and the environment. Next, the system that produced the voluntary agreements lacks fundamental legitimacy and is the result of inequitable processes that exclude Native American tribes, communities of color, and the general public from participating in water quality governance. For years, the board has delayed updating Bay Delta water quality standards to accommodate the exclusionary negotiations of the VAs. The voluntary agreements are not negotiations between interested stakeholders and various state agencies, as the VA parties claim. The truth is that the only entities given a meaningful seat at the negotiating table or access to it at all are water agencies, water contractors, irrigation and water districts, and private companies. Despite the board noting that it intended to accommodate the voluntary agreement as a pathway for updating Bay Delta water quality standards, no tribes were ever consulted about the VAs, invited to participate in the negotiations, and no tribe is a party to the negotiations. By endorsing an instrument that excludes tribes and communities of color throughout the Delta, the board has failed its commitment to meaningfully consult with these communities most impacted by water quality management decisions. The board, as well as other public agencies entangled in the draft global agreement, have clear obligations under state law and their own internal policies to meaningfully consult tribes in evaluating policy proposals that may impact tribes and their unique relationship to waterways. As they are now, the voluntary agreements present the board with a take it or leave it deal. How does the board plan to incorporate the feedback provided to them today and through other public proceedings if they cannot meaningfully modify the VAs in response to public input? Worse, the board is allowing the VA parties to workshop still incomplete documents outside the contours of the environmental review process. For the past 7 years, the VAs have been a painful distraction from the real work before the board, the legally mandated task of updating water quality standards to ensure reasonable protection of beneficial use and public trust resources. The board must let go of the VAs and put its resources into regulatory measures that protect beneficial uses and public trust. Thank you.
Makena. Hi, I'm Delaina Castillo. I'm also a student attorney representing DTech. Thank you for the opportunity to comment today. With the context Makena provided us in mind, I will comment on 3 reasons why the VAs cannot serve as a basis for the Bay Delta Plan update. First, the VAs are irreparably tainted. As explained earlier, this history of exclusion throughout California water rights has clear through lines to the voluntary agreements today. The VAs, developed through backdoor negotiations, cannot be cured of their exclusionary defects by bringing them forward now for public review and agency approval. As Makena said, the VAs are a take it or leave it deal. They are decided upon contract that neither the board nor the public can meaningfully comment nor change. Second, the VAs are an unlawful delegation of the board's regulatory authority. The board cannot confer its regulatory authority on private parties. I'm sorry, actually, can we go next slide? So sorry. As I was saying, the board cannot confer its regulatory authority on private parties. In Light v. the State Water Resources Control Board, the Court of Appeal recognized that the unlawful delegation would occur where the board delegates its regulatory responsibilities to regulated parties without adequate policy guardrails and without maintaining ultimate authority to formulate and exercise governing standards. This is exactly what the VAs contemplate. Based on the documents provided, the board's role in these VAs is opaque at best. The enforcement agreements do not provide adequate policy guardrails, as the board cannot seek additional contributions from the parties once the agreements are signed, are expected to expedite permitting, and an only review of the process is provided through the Governance Committee's presentation of annual and triennial reports. The board will not have an opportunity until 8 years after the VAs have been in place to make meaningful changes or decisions regarding the VAs. All the while, our water quality and systems, which are depended upon by Native tribes, local communities, and ecosystems, will fall into further disrepair. The board's participation, or lack thereof, in the system-wide governance committee is also alarming. According to the draft VA governance program, the board will not serve as a voting member and will utilize the annual and triennial reporting of the VA parties in their triennial review. This flies in the face of the board's legally mandated review requirements under the Clean Water Act, Title 33, Section 1313C1, which requires the board to hold public hearings for reviewing and modifying water quality standards. The board cannot exercise this responsibility if it is shielded from review of VA implementation and obtains insight only through the self-reports from VA parties. Third, the board cannot adopt the voluntary agreements that are appended to the current draft SCD without violating CEQA. Despite still having an incomplete VA package, these workshops are being held. After these documents, we are still missing how California tribes will be engaged, how membership in the System-Wide Governance Committee will be determined, and how decisions by the System-Wide Governance Committee will be made. Many of these missing components are key to understanding the role that tribes and affected communities will play in shaping the progress and the outcomes of the VAs. So I asked the board, will we have the opportunity to comment on these aspects of the VA package? One of CEQA's core tenets is the opportunity for the public to meaningfully comment on environmental documents. Again, this workshop reiterates one of the central legal flaws of the VA package. How can the public meaningfully comment on an incomplete set of documents? Further, several of the additional documents, including flow accounting measures, were released as late as this week. We are also still missing an enforcement agreement for FREAT, which will, like the other enforcement agreements, play a role in determining water quality and water quantity standards. The poor timing of release for these documents, as well as the absence of the documents, serves to impair public participation. The board should not consider the voluntary agreements as a legitimate solution to managing California's water quality and quantity. Moving forward with the voluntary agreements would mean playing an active role in furthering the exclusion of tribes and communities from water governance in order to allow private entities to experiment with our water and ultimately leaving the Bay Delta worse than we found it. Thank you.
Thank you.
Thank you. Good morning, Chair Escobar and members of the board. My name is Cintia Cortez. I am the policy analyst with Restore the Delta. My comments here today are informed by my lived experience as a lifelong resident of a historically marginalized urban Delta community and my undergraduate education as an environmental scientist. The voluntary agreements are written, allow the VA parties to negotiate their own terms for the mismanagement of Delta flows. It is not a complementary regulatory text to a completed Bay Delta plan. It is not intended to protect all beneficial uses as defined in the Clean Water Act, and thus proper governance cannot be created. Throughout the course of the 3-day workshop, our partners have raised many valid concerns and questions that have remained unanswered by the documents provided. The package currently being discussed is incomplete and it's nowhere the 90% level of completion that was claimed by VA parties during Wednesday's session. Additionally, the board has given the VA parties nearly 9 years to complete tribal consultation, to engage with environmental justice communities and local Delta government entities, and to complete a proposal ready for presentation to you, the regulators. They have failed on all fronts. There is too much at stake for Delta communities and for tribes, and truthfully for the board to justify aiding delay with new governance structures. The VA party's insistence on moving forward with the VAs and the State Water Board's willingness to oblige to VA parties demonstrates the lack of full commitment from the board to incorporate equity into its policies and decision-making processes. We have listened to the VA parties scrambling to offer a pathway for inclusion. We told you and them years ago that this was a problem, and the board's willingness to elongate the VA process is a step backward into patterns and practices of regulatory failure for which it has already had to settle in court. In light of the EPA's investigation into our Title VI complaint, the board should redirect its energies. Last, the synthesis of work around HAB's partner monitoring strategy is presently an unfunded program that would possibly take years to implement in order to work towards better practices around HABs. Even in this rapidly growing effort, which Restore the Delta is a community partner, there isn't consensus on the full purpose of the program. There is an emphasis on research, science, and reluctance by state agencies to engage in applied science, which could protect community. This science committee is not ready for inclusion in any governance plan. Thank you for the opportunity to comment today.
Thank you.
Good morning, Chair and Board. My name is Gloria Alonso Cruz. I am here representing Little Manila Rising. Over the past 20 years, our organization has grown to focus on a variety of social justice issues in the broader South Stockton to address the needs of our diverse communities who have been traditionally marginalized by discriminatory policies. I understand that this panel is meant to focus on participation in governments, but I would like to briefly take the opportunity to comment on a community science and protection as well as governance, because from the community perspectives, all of these elements are intertwined. To continue to emphasize, during the 8 years that the voluntary agreements will be in place, the estuary will be overrun with deteriorating environmental conditions, such as the proliferation of the harmful algae blooms, and among other environmental conditions, such as should the drought conditions return. This means fisheries will fully collapse. We urge the board to use the best available science related to flows in the present by which to set numeric standards for public health protection. Furthermore, we need adequate freshwater flows, not experiments, to address our immediate public health risks first, and then expand the research to develop advanced mitigation strategies for harmful algae blooms, for example. This is the correct order to solve the challenges. This remains a concern because regardless of the outcome of this discussion today, the ongoing board's consideration of the BAs is a distraction from the necessary and the essential work in upholding the update of the water quality standards through an update to the Bay Delta Plan as a priority it is. This delay has resulted only in increasing harm in beneficial uses and public trust resources. Addressing HABs will not fully solve the bigger challenge around public engagement and participation within governance. Chair Esquivel raised a valid question and a crucial one, which quoting, where is the front door for the public to engage in the voluntary agreement process? There is none, because the process has deliberated in a locked room from which we are barred. When visiting the CNRA websites, the VA participants are described as agreement collaborators. I highlight that it says collaborators and not signatories, representing water and irrigation districts along with government agencies whose mission is exporting water. Moreover, the publicly available VA's documents log clear guidance on how tribal and public input will be included in the VAs, if that's even a real consideration on the table. This process exacerbates the exclusionary foundation that the VA rests on. To continue emphasizing the challenge, the cover sheet of these additional documents is explicit that the VA parties still do not know how California tribes will be included, nor how the system-wide governance committee will make decisions on how will be or who will be in the committee. This lack of clarity was vaguely addressed in the first panel and reaffirms our concerns. This is a clear barrier, and as the committee is the only one that will actually oversee the VAs and has the power to make recommendations to them if they are enacted. The VA's parties and resource agency are running a high-stakes messaging campaign and misleading the public to believe that the organizations that are trusted and rooted in community are at the table helping to make decisions that will protect them. The communities we serve aren't here today because they're keeping food at the table and a roof over their heads. Having the opportunity to advocate is actually perceived as a privilege in our community. These communities depend on us to advocate for them in spaces from which we as representatives have been traditionally shut out. How can governance be created on this flawed foundation? The board should not be a party to an effort conducted in this manner as the regulator for the people. Lastly, a 90-day comment period should be the standard for community. This will allow the board sufficient time to host informational workshops for the public to digest the information and the documents and to draft thorough and informed responses. Thank you for the opportunity.
Thank you.
I had to write it down because I didn't want to accidentally go off the rails. So I'm going to try and keep my focus here, but it's not pleasant. First, I'd like to thank the chairman and the board for allowing us to be here to present. We appreciate the opportunity. My name is Gary Mulcahy. I'm the government liaison for the Winnemem-Wintu tribe. My tribal name is Ponte Tiawas. Our tribe is a member of the coalition known as the Delta Tribal Environmental Coalition, or DTEC. You have heard and seen presentations from members of DTEC throughout the last 3 days, and of course, throughout the last few years, and you're probably tired of hearing from us. But we're coming, we're still here. I've been asked to provide closing remarks incorporating those comments and what you have heard today, as well as some others, and what you're going to hear later on today. I know what's coming. But I want to state by asking the big question first: why are we here? Why must we be here? And why do they have to be here? They, meaning the voluntary agreement people. I think I can answer those questions, at least in part. A big reason is because the Bay Delta Plan had its last overall complete update in 2006, but the last major update in 1995. That's 18 and 29 years respectively. Who wouldn't want to at least put something on the table to try and combat the lack of leadership and direction regarding the public trust and beneficial uses of one of California's most sacred resources, water? I can't fault them for wanting to do something. I'm a little bit at a quandary today too. I just spent a day and a half in a salmon homecoming summit talking with some of the folks who have worked on and are promoting these voluntary agreements: farmers, water districts, NGOs, settlement contractors, and many others were there. We actually talked with each other. We actually heard each other about common purposes and that is getting salmon back into the historical spawning grounds all up and down the North State. It was great. We worked together to try and find solutions and develop an overall strategy. It's shown each of us what can happen when we lay down those barriers between us. And we carry some of that to the table with common cause. Unfortunately, that is not what happened here. In the 8 to 9 years, these voluntary agreements have been talked about and developed. California tribes, disadvantaged communities, environmental justice concerns, NGOs, and even the fishing industry has been excluded from the table. That represents at least half of the population of California, if not more. And you can see what the results that exclusion are by what is and is not contained in these voluntary agreements. I could, but I won't reiterate all that has been presented to you over the last few days, whatever it was by personal testimony or by written comments. Hopefully you actually heard what has been said and what is being said. I will, however, point out one glaring truth surrounding these voluntary agreements. The exclusionary tactic of keeping California tribes and communities of color out of the decision-making process of these agreements only perpetuates the racial and discriminatory practices that have been in place since the beginning of water policy development in the state of California, which is still ongoing today. Do your job. Complete the Bay Delta Plan update. Reject these voluntary agreements at least or until you have fulfilled your responsibilities under the law. That is all we ask. Set the water quality standards first. Determine the implementation plan first. Define the necessary beneficial uses first. Then we can talk about other things and other projects. But you must do these things first and foremost above all. Thank you for your time and consideration. And we're not taking any questions. Thank you.